You have to remember to turn the microphone on. Hello, everybody. Welcome. Thank you for being here today. Nothing is working. There it is. Okay, good. We're good. Adriana, how are you? Haven't seen your name out in a while. Hope you're doing okay. We are at the Greater San Diego Association of Realtors, and my name is Kevin Burke, and there is my telephone number. I'm a little difficult to get a hold of by phone, but I'm much easier to get a hold of by email. Don't worry about time zones. Send me a message. I'm more than happy to help you in any way that I can. That's kind of what I live for. So some of you on this call today know that. So anyway, that being said, let's see. What else? JD, I have a Juris Doctorate degree. We'll talk a little bit about that in a minute. I do have some credentials that I guess make me qualified to speak about the subject matter today. I keep trying to tell people that I'm not actually, I don't really know more than anybody else. I've just lived longer than anybody else. And so I have a broker's license in several states. I do teach. I'm a certified DPOR instructor in Virginia. I teach DRE classes here. I have my RPA was approved for 5 hours of continuing education credit. Hi, Mary. Welcome back. And my BRBC, my Buyer Representation Broker Compensation Agreement class has been accepted, 3 hours of continuing ed. I'm just waiting for somebody to say, come teach it. So at that point, we'll do that. So I do continue to teach continuing education for attorneys at UCSD Real Property Law. And let's see what else. Gosh knows I'm a chair of everything, right? Risk management is my game and continues to be so. And I do a lot of defense work for, well, let's talk about that. So anyway, we're going to talk about stuff that's going to appear to be legal. I am not a practicing attorney. Have no interest whatsoever. I do spend a lot of time in court. Unfortunately, I have another case starting on Monday, but trial work is limited to testifying as an expert witness. So I am a court certified expert witness. Standard of care. Did the agent do what they were supposed to do? You know, those kinds of things. Agents' duties of inspection and disclosure, and then finally market conditions in San Diego County. And so our conversation is not intended to be a substitute for the advice of your broker nor for that of your attorney. And so please consult with them as appropriate. You're paying them to be there. And so they should be helping you. And I'm sure they would rather, I always said that the ones that are quiet that I never hear from, those are the ones I worry about. But for the most part, nowadays, most everybody's pretty good about contacting me when they need something. So good deal. All right. Our talk today is intended to be interactive. And so please ask questions or offer input by utilizing the Q&A button. So down on mine, it's at the bottom of the screen. Just type in your message. I should tell you that this conversation is being recorded. However, nobody can see you, nobody can see your questions, nobody can see your name, so you're pretty much anonymous. Again, so if you're shy, this is not a good platform for that. But again, I will help you in any way that I can. So I do look forward to hearing from you. And so since today we're going to be talking about risk reduction, risk management, it's probably more important than ever that if you're seeing situations or you have things that are going on, I can always speak in terms of hypotheticals, but I won't get in front of your broker. So, okay, that being said, this morning we did residential property management. That was a lot of fun. And so 2 hours. And when I'm done today with this webinar, I will load both of these webinars up onto our YouTube website, which I will give you the link to that when we get to the end here today. I have a QR code. I learned how to do that. I've got bit.ly links. I've got just all kinds of great stuff. So anyway, I will load those up onto the YouTube website. It's phenomenal to me how many people are going there and watching the videos. And so those are the webinars, but now I'm into podcasts as well. So for San Diego, I've been doing webinars, but I'm going to create some individual podcasts that we will be releasing. For example, I don't believe I'm on calendar at SDAR to teach the new forms prior to the release on the 16th of December. I think the 14th is my last class. I don't know what next year is going to hold, but I'm going to do a podcast on the new forms. And so that'll be kind of setting my own schedule now and doing that. And those will also be up on the YouTube website and then through other various media, things like that. So that being said, today now we're going to talk about maintaining records and reducing risk. And so we're going to get really deep into the weeds of the Department of Real Estate's position on these things. And then I'm going to show you some really easy ways to make sure that you're doing it and make sure that you're doing things right. On Tuesday, we will have Tuesday morning from 10 to 12, we will have all about disclosures. Interestingly enough, the chair of education, Judy Preston, who is a wonderful lady, I had such a great conversation with her yesterday, and she said, boy, your stuff on disclosures is always good. And so I thank Judy for that. That's going to be fun. We'll have a good time with that. And then in the afternoon, I'll be talking about the 4 biggies, right? These are the ones, if I'm going to get hauled into court over something, it's going to be, something that was done wrong here. TDS, of course, is a statutory form. The SPQ is contractual. It's intended to explain the TDS. The SPQA is intended to explain the SPQ. And then the AVID, the AVID, remember the TDS is not considered complete until the AVID, the seller's agent's AVID has been delivered to the buyer. And so those are some key little points that are kind of important in yours and my world, so that we make sure that, we have a completed transaction. And as I've been teaching for many decades now, give the buyer all the disclosures prior to contract, and the 3-day right of rescission is probably going to go away. So I've been pretty successful with that. That being said, let's see, next, member benefits. So now we're going to thank you for joining us, and we're going to talk about risk management. Let's see here. And I always say reducing risk. So I remember talking to a big broker about a situation that he had going on. And I remember saying that, based on the way that it was getting handled, it sounded more like that he was not doing risk management, but more damage control. And so I kind of always felt that if I can reduce my risk in the beginning, I'll have less damage control to handle. And the interesting comment that the broker made was, cat's out of the bag. I've got all these agents working for me, and I can't really, have any control over them. And I thought, well, that's kind of the opposite of what the DRE is looking for. But his comment was, I hire all these attorneys, and if something goes bad, I just send it over to the attorneys and let them handle it. And so at a certain point, that can be a very expensive thing to do. So when I was management with the Rock people many years ago, my job was to keep things from getting to the attorney. I had 188 agents under my supposed control. And so I could usually get rid of things, without them ever getting to the attorney. I maybe lose like one a year that would go up to counsel. And I remember years later, a broker who used to work there came to me and said that I was known as the cleaner. And so I didn't know what the cleaner meant. She said, well, you cleaned up all the messes. You got rid of the bodies and the blood and all that before it ever became a problem. And so that's kind of what I'm going to talk to you about today. I want you to be the cleaner. I want you to be the one that can get all this stuff done, but you also have to understand the concepts behind it. So again, reducing risk and your peace of mind, keeping that together. So when we talk about the structure of maintaining records and why it's key to your peace of mind, we're going to talk about several things. We're going to talk about the who, right? We're going to talk about the what. We're going to talk about the why. We're going to talk about the when, the where, and the how. And those are the how will be the finishing touch on everything. And with any kind of luck, I'll get you out of here before 4 o'clock, and hopefully that'll happen. I was in a lot of these webinars that I've been doing. They scheduled me for 2 hours. Some of them really can't be done in 2 hours, like the BRBC, the buyer representation agreement. It was a 2-hour webinar. When I do it live for DRE credit, that'll be 3 hours, and I really feel 3 hours is not enough time. So be aware. Today I could probably go over 3 hours pretty easily, but we're going to try to get done before 2 hours, okay? And probably give you a little chance to get started on your weekend. So the who's. So let's talk about the who's. So do you interact within your real estate transaction? And so I get enough. Unfortunately, we're going to talk about lawsuits today, and the things that I see in the lawsuits. Do you send things over to your transaction coordinator and have them send it to the client and say, here, if you have any questions, let me know? That is a very, very poor defense. I can tell you that I am writing a paper for the Department of Real Estate right now on the issues of transaction coordinators. I'm doing this with another broker. We're putting this together, and because of the problems that I see in the world of transaction management and legal advice and things like that. And so I have a lot of situations. I have a transaction we just recently closed where the agent was working a full-time job, and so the only time that they'd ever get back to us was when they got off of their job, and so but everything was given to the TC, who thought she was an attorney. And so my question for you is, do you interact in your own transaction? Are you there? Are you representative of who you're supposed to be representing, whether the buyer or the seller? Now, we would all agree that it's usually the buyer who sues, right? So, you know, let's understand that if you're the seller's agent, you want to be thorough about what you do to protect yourself from the other buyer. And if you're the buyer's agent, sometimes you have to create a file to defend yourself. And so, you know, but are you interacting within your own transaction? It's going to depend on your record keeping procedure. Whoops, I can't see all that. Where is it here? Linda, help. It is going to depend on your record keeping procedures in your transaction. I'm going to show you some easy tricks to make this really good for you. And Adriana, before I forget, make sure that I mention at the very end here today about how to send an email to the file straight out of the transaction. In fact, you know what? I'll tell you what, I want to show you right now. And here's why, because I don't want to mess this up. I want to make sure that you know what I'm talking about. So I'm going to go in here into a transaction that I created. I guess we'll call it a dummy file. So I've created a transaction, and normally we go to documents. But right here, folks, does everybody see this where the drop down is? I want you to see that drop down. I want you to go over here where it says email to transaction. So I want to click on that, and it pops up an email address. Now, this email address is specific to this file. Okay, so if I copy this to another transaction, I'll get a different address. I'm sorry, I'll get the same address, and it's not going to do you any good. Copy this address, save it. Whenever you send an email out of your email program, whatever you're using, Outlook, Gmail, whatever, you would include this in either the CC line or the BCC line. And when you do that, every time you do that and you send an email, it will automatically load a copy of that email into your zip form program. It'll show up over here on the left-hand side. It'll say email to transaction. And so now you've saved your emails. And that is one of the most important things that I see missing in most files that I go through. Whenever I get it, whenever I'm involved in a lawsuit, I'm usually looking for those emails. I had a transaction, a lawsuit. They're always somebody else's, right? I kind of like that, but somebody else's. I mean, I had like 10 banker boxes full of emails, printed emails, because they print everything and send it to me by print. And so, I mean, it made me very happy because I was looking at all those emails and I thought, wow, these guys did a really good job of documenting their file. Now, they did it the old way. They literally printed all their emails. This will save you having to do that. This will save everything into your transaction so that you have that for later. And remember, you want to keep things for 3 years because the DRE requires it for one thing, but also because if you're going to get involved in litigation, it's probably going to be within that 3-year mark. Okay. So anyway, there's that email address specific to this transaction, and you're going to include that in all of your emails that you send outside of this transaction. In this transaction, you don't need to do it. If you're sending your emails out of here, so for example, if I open up my, where's my offer? Here's my offer form. If I open up the offer form, I'm going to go back because I don't need all that, but I did that wrong. Okay, I should have done it that way. Okay, so I'm going to go back here. I'm going to send this offer for review. I click the right-hand side. I click on send. You're essentially sending an email out from within this program. Okay, so I'm going to encourage you to do that. So you put in the name of whoever you're sending it to, and then when it goes, it's going to do this. It's going to show up here under history, and that history will tell you. See, I just created this one. Is just kind of a dummy thing I put together so that I could demonstrate some things. But all of your notes, your notes will go in here. Your history will show everything you've done in the transaction, and that's what I want you to do. So when, if you call me on the phone, and I do a lot of DRE audit, you call me on the phone and I'm in your office, I want to see all these things. Okay. All right. Is everybody good with that? Good. Let's go back to my PowerPoint. So the record keeping, I had a lawsuit where a seller that I was representing was sued by a buyer before the closing, actually, because they wanted to buy the property and the seller wouldn't sell it to them. Kind of a long story. I keep trying to think of the name of the attorney who actually got disbarred as a result of all of that. And so the judge at trial, 2 years into the trial, and the judge said it was our record keeping that saved the day. And folks, this was back before cell phones. This was when fax machines had just come out. So everything we did was faxes back and forth, thermal paper, by the way. And then we also did, we took notes as we were talking to people. So be aware, there are a lot of ways to protect yourself, and that's my job here today, is to show you how to do that. So who are you protecting? Who needs to keep the notes? And the answer is you clearly do, right? So there's a principle of law. It's called a contemporaneous note. So if I'm having a conversation with somebody on the phone and I'm taking notes of that conversation, it doesn't have to be word for word, right? And don't record. I mean, you can record conversations. It's just they're inadmissible at trial unless you had consent. So a lot of people think it's illegal. It's not illegal. It's in the legal field, it's entrapment when law enforcement does it, but it's inadmissible at trial. But you can take notes, you can write things down, you can do stuff like that. And I'm going to tell you something. If you're taking notes at or about the time that the conversation occurred, they tend to be admissible trial if that's your practice in real estate. If that's your practice in a real estate transaction, then they're probably going to be admissible at trial. And by the way, if you're taking notes, you're probably the only one taking notes. Okay, so you can imagine what that's going to look like. In our scenario with that one lawsuit, again, we were the only one taking notes. Nobody else had anything. We had everything. So good. Okay, your assistant, your transaction coordinators, assuming that you're using one, I believe more that you should have an assistant than a TC. A lot of times a TC doesn't work with you directly. They work on your file for you. They're sometimes in-house, sometimes third parties out there, but they need to be taking notes, and you need to have their notes. And so we have a broker in our office who has a transaction coordinator he's been using for years. She's doing what I just showed you a second ago, the ZipLogix email, and then she also loads all of her emails and all of his emails up into the program prior to the transaction closing. And so when I'm talking about that, I'm over here. So this is our template. So over here, I have on the left-hand side, I've got my conversation log, and there is a form in there called the confirmation of conversation. I put that in there just because I wanted you to know that there is actually a form that we suggest that you have. This was kind of taken from Jackie Oliver's confirming letter, which I'm going to show you also that in a minute. And it talks about, here's what the letter looks like. On page 1, you delete that. But, we had this conversation. I told you to do this. You said you were going to do that, something different. And so, it's going to be a problem for us. And so anyway, so on the left-hand side, where I have conversation log, that's where all those emails are going to get loaded. When I do the email to transaction, there will be a separate folder that will be created that will load all of those into the transactions. Everybody good with that? Real important. I want to keep records of everything that I do. Okay. And I need cooperation from the people that are helping me. We had an agent who was doing 822 transactions a year. He had 7 full-time assistants. I mean, this man was a machine, right? And all of them paid, and all of them, had the whole thing, taxes, workers' comp, the whole thing. And so he did a really good job, but he was very thorough, but he had really good group of people working with him. Okay. So Your broker wants it. Your broker absolutely needs it, because at the end of the day, when you get in trouble for something, it's going to be something that the broker is going to have to defend. And so again, you're with your broker. Your broker's there to support you. Your broker's also there to defend you. So you need to make sure your broker has everything that you were doing. Okay, and we'll talk more about that in depth in a minute. Your lawyer clearly keeps track of everything. Every time I talk to an attorney, they remind me of a conversation I had with them 6 months ago. And so it's like, I don't need to look that conversation up. I know that was the conversation. But they are going to be doing that as well. Okay. So of course I forgot to turn my phone off. I normally put that on do not disturb. I apologize. There we go. Okay, so and then the DRE requires it, and we're going to talk about the DRE's requirements here in a minute, because they have some specific requirements for your record keeping, and then of course California law requires it, and so we want to be compliant with the law. Okay, all right. Questions so far? Anybody have any questions so far? Any of that? So I'm going to take us to the commissioner's information. If I can find it. Let me see here. That's well, the confirming letter we talked about a minute ago. This is Jackie Oliver's version of this. She's an attorney on San Diego's risk management committee, and actually, I guess it is a committee. It actually puts rules forward. So here's her confirming letter. I will send all this to you. Send me an email. I will send it to you. I just think Jackie's brilliant. She's barred in 4 states. She's an attorney. She's a concert pianist. She's excellent with a piano. But this is her version of the confirming letter. And so it's a little bit simpler than CAR's. Here is an example of a confirming letter that I wrote to Linda, to myself as an example, and then copied Linda. She's known as Sarge because she's Sergeant at Arms at the California Association of Realtors. And this is confirming our conversation. And so real simple. This is intended to confirm our conversation a few moments ago. Regarding my suggestion that you not write a non-contingent offer. If you choose to move forward, I want it to be very clear that it is against my advice. Okay. And so if any of the above does not comport to your understanding of that conversation, please let me know immediately. Now, and by the way, I should also tell you that CAR has a version of a confirming letter. And so down here under sample letters, everybody see where I am? Sample letters. And so here it is, acting against the broker's advice letter. Okay. And so I actually have that in here. And let me pull it up for you really quick. Where did it go? I don't know, dear. Well, I'll tell you what, we'll just write it out. So acting, ACT. There it is, acting against broker's advice. And so this is CAR's version of the letter, or what we were just talking about a second ago. So pretty good little letter here. Again, I told you, you remove a contingency before the time required by the contract. I told you not to do that. You chose to do it, et cetera, et cetera. Is everybody good with that? I'm going to go ahead and get us out of here. I'm sorry. I know I'm going fast, and I was actually in that conversation with Judy Preston, the chair of our education committee. She made a really good suggestion to me, and that was slow down. Well, it's really hard for me to slow down. So and part of it is because you're not asking questions. So if you're asking questions, that it'll help me to slow down. Okay. So all right. So again, I want to show you the commissioner's information. I distracted myself. So back up here again. There's a third. Here's the sample letter. Then we got the broker's compliance manual. And so if you are a broker, and I know we do have a couple brokers on the call today, if you are a broker, this manual is pretty handy. It's a little dated at the moment, but it's 4 years, I guess. That's pretty dated. But that's the current one that they have, and I would suggest that you go through this. They do, obviously they're in charge of compliance, and so agents being properly licensed. I send this to brokers all the time. I do a lot of consulting with brokerage firms, and something they could find on their own, Are you properly supervising? Things like that. And so I say, are you doing these things? And I'm not sure they ever really read it, which is really kind of bothersome for me, because I took the time to find it, to send it to people, and I expect them to actually take a look at it. Here are the commissioner's regulations. And so these start at Title 10, Chapter 6. And these are the contained in the California Code of Regulations. But these are the regulations of the real estate commissioner. I don't know how many people have actually ever read this. I mean, some of it you're not going to really care about, like special fees and stuff like that. But when I go through here, I see some things in here that are enforcement activities that people need to be really taken seriously. And so I wanted at least to present that to you, to make you aware that it is out there. And then, of course, we have the Business and Professions Code. I actually pulled this out of the code. So I always call it the B&P code, because it is business and professions, and the commissioner gets their information out of this. So here's some of what we're going to talk about today came out of here. Okay, and then finally the bulletin by the commissioner. Listen, you should be getting this bulletin. I want to show you. I'll take you to the website here really fast. Where is it? Here we go. I'm going to go to the DRE's website, and I'm going to pull up. If I can get my mouse to work properly, the DRE. I'm in the DRE website all the time, and so down here, about a third or 2/3 of the way down the page, there's this orange link right here, folks. Everybody, Mary, you see this where it says RSS? That's RSS feed, right? And so if you don't know what RSS stands for, it's really simple syndication. I'm learning how to create one for my stuff as well, and so that people can subscribe to the feed, and it'll tell them what's going on. But when I click on that, it allows me to actually put my information in here to subscribe to the website updates and also to the news clips. And so I've subscribed to both. I would recommend that you do the same thing. Back when I first got started in real estate, before they invented dirt, right? So we used to get a real estate bulletin sent to us. I'm not sure that anybody on this call today has had a license long enough to remember that, but they used to send us a real estate bulletin. And the bulletin was like 8 or 9 pages of stuff. In fact, it's the same bulletin that we look at when I pulled up the commissioner's bulletin a second ago, which was this one. It's the same thing, right? This was the spring of 2023 bulletin, but it was in print form. And once we hit past like 100,000 real estate agents, and I was well within that number. I was 010000175. That's my DRE number. And so I was back there during that period of time when we got this in print. And so now they realized that they were going to have to save money, because it was costing them a fortune to send this thing out. So, but they knew it was important. They wanted people to have it. We weren't big on the internet, that kind of thing. And so then over time, they realized they could create the newsletter, but they don't have to have your email address. They just give you a place to put it so that they can send it to you. So again, it's got all kinds of great. I read this every time it comes out. I read it, but this is what it looked like. Was I'm going to put in my email address in here. I'm going to put my email address in here, and I'm going to say, go send me this thing. Okay. And so, I mean, you can unsubscribe, you can do all kinds of stuff. I would recommend against it, but I would for sure be doing this. I think it's like up at the pinnacle of risk management. I remember meeting, I was chair of risk management last year for the California Association of Realtors. And I remember after one of my meetings that I just chaired in Sacramento, I went around the corner. The commissioner was holding his meeting, and I walked in, and actually it was really, just to tell you, I had just done a 4-hour webinar for the Department of Real Estate, explaining to them what the new RPA does. So I guess it's no surprise they approved my RPA for continuing education credit. But 400 special investigators, the commissioner, all the assistant, everybody was there. Anyway, so I didn't realize what kind of impact. I just knew I had a heck of an attendance at this thing. Everybody was there. Everybody was asking questions. Everybody was taking notes. And so here I walk into the commissioners meeting in Sacramento at the convention center. And as I'm walking up to the, all of the body politic up there, all the commissioners were up there. And then one of them goes, you're that guy. So I went, uh-oh, usually that means I'm going to be served a subpoena or something, but you're that guy. And it was like, oh, you're that guy on the internet that showed us how to, what this was all about. And it was like a crowning moment for me. I was very proud. And anyway, I said to the commissioner, I said, you know what, we're in the same business. I just finished chairing realtor risk management and consumer protection, and you are and consumer protection. You are specifically that. And he agreed. He said, and this was Macaulay, who was the current commissioner, and he agreed. He said, yeah, I'm in charge of that. And folks, you and I are as well. We're trying to protect ourselves, right? But in doing that, we should also be protecting our client. And I think that's really, really an important observation. So please do me the favor and get that RSS feed. Sign into that. And Commissioner Macaulay, I think he's done a great job. I've been very close with all the commissioners. Wayne Bell, probably among my favorite. He is an attorney, and he's doing well, by the way. I talked with him every once in a while, but he is running a art. He's the attorney for an art company. So anyway, super guy. But I have stories on all these people. You don't want to hear it. So anyway, so I always said you want to make sure that you're always on the right side of the guns and badges, right? That's just always been my thing. And so we looked at the commissioner's information. Let's go on from here. So what do you have to keep? Anything material to a transaction. This is very important. Anything material. And so, what is material? Well, let's talk about that. Sales associates are required, and I do want to tell you what it is, but give everything to the broker within 72 hours of receipt. All right. I rarely ever see that happen. And so why? Because the broker's got 5 days from receipt to decide what to do with it. 5 days from when it happens to decide what to do with it. So if you give it to the broker within 72 hours, they have 48 hours to make a decision as to what to do with it from that point there. It's a very big job being a broker, okay? And so, in my experience, I was management with the rock people, and people would give me their file for review because I was the guy that approved your check, you getting your check. And so I'd have people come into my office and they would hand me a file and they would say, here's the file. And I just want to make sure I get paid. And I'd say, when's it closing? And they'd say Friday, right? I go, what do you Friday? So when did it open? Well, it opened, a month and a half ago. Well, all of the power that we had as a company to be able to refuse something or to do anything with something is gone, right? Because we had only 5 days. The commissioner's regulation says we've got 5 days to make a decision from when it happens, and you're handing it to me the day before closing. We're going to have a problem. And so, for those of you out there that on this call that are brokers, you need to have a very strict requirement. So 72 hours is the requirement that the DRE has for sales associates, whether you're a broker associate or a sales associate. Your written agreement with your broker may require less time. So in our office, we run a fairly tight ship. And so, and you can figure I'm probably really, really good about that, right? And so, and by the way, our agents never leave. So it's like, I guess I'm good to work with, but, we make sure you're taken care of. And but our agreement with our agent says that we will get that, you will give that to us within 24 hours. So we have all kinds of ways to do that. We have, we have the Zip Forms account, we have the Dropbox, we have the Google Drive, we have all kinds of ways for people to get stuff to us within 24 hours. Everybody okay with that? So again, your broker, your agreement with your broker can require less time. And ours does, because we want to make sure that we respond quickly to things that are happening. And so, good. Okay, so any questions? No, seeing none. Whoops, wrong way. All right, so 72, what am I doing here? I went the wrong way. Anything signed by a party. So as a general rule, and I'm going to slow down a little bit here because Judy said I need to slow down on the really salient parts, the really important. This is really, really important. Anything anybody signs, folks, you need to get it to the broker within 72 hours, or if your contract says less, do it in that period of time. Whatever your broker says, it can't be more than 72 hours because the DRE says max 72 hours for the sales associate. Okay, so anything is signed by a party. That includes, by the way, transactions that don't close. So this is, I walked into a broker's office. It was a couple months ago, and I said, what do you do with your DFTs? And so DFT is an old term for deal fell through, all obviously signed by people. Oh, we just throw them away. And it's like, oh, no, no, that's a very bad thing. You don't want to be throwing these things away. They were signed by people. You have an obligation at law to keep those for 3 years minimum. Okay. So whether closed or not. So if their transaction didn't close, they were throwing everything away. Well, that's just not going to work. That's clearly not going to be compliant, because the DRE doesn't say only if you got paid. The DRE says 72 hours of receipt. So just as a general rule of thumb, anything anybody signs, okay, I'm looking for material to the transaction. Even the PR, for example, which unfortunately most brokers don't have their clients sign them. I work with some really good brokers that do, by the way, make the buyer and the agent sign the PR, the preliminary title report. I've done a lot of these 2-hour webinars on how to read a prelim, and I'm shocked at how many people will actually go back and watch those videos again. It's phenomenal numbers. I was in a restaurant in where was I? Charleston, Virginia, having dinner one night, and I was doing a presentation there, and get a phone call. And I answered because I answer my phone if I can, and the guy says, I just finished watching your how to read a preliminary title report, and it was brilliant. And I go, wow, I didn't know anybody even went to those things. I've been uploading them on the YouTube, and so I said, well, thank you very much. I appreciate that. And who are you? And he says, well, I'm a buyer. And I went, uh-oh, okay. So I said, well, listen, I can't give you legal advice. I don't want to get in front of your transaction. He says, well, I asked my broker what the PR said, and they couldn't explain it to me. And then I called the title company, and they wouldn't explain it to me. And I was really surprised, because usually the title officer, somebody there will go over the PR with you. But in this case, they hadn't done that. So anyway, if you get a chance and you want to actually know how to read a preliminary title report, you might want to take a look at the video that I've loaded up onto the YouTube website. Okay, so even though that's not necessarily signed by a party, I would have it signed. Okay, all right, all disclosure statements clearly. Okay, any disclosure, because like I said earlier, if I'm going to get hauled into court, it's going to be a non-disclosure issue, and so I want to keep all those disclosure documents, and we're going to see what the rule says in a minute. And I'm going to tell you that I don't agree with the rule. This one particular rule, I'm going to want more time. Okay, I want you to keep it longer. All right. So, and disclosure statements be either statutory or contractual. I don't care. TDS very clearly, right? SPQ, yeah, contractual, but yeah, I think you need to keep it. Okay, even if you don't keep anything else. All right. Okay, so any correspondence related to the transaction. We've talked about that already. I have my correspondence log in my program, right? So over here on the left-hand side where it says conversation log, sorry, it's a little bit of a delay for the screens to change, but conversation log, everything's going to go in there, okay? I want to keep everything in one place. And by the way, the DRE likes this program. The DRE says, if you keep it in one place, maybe keep it in zip forms, that kind of thing, because that's our standard of practice. So okay, so parties, who's there? Remember Privacy Act. Remember it has to be secured. And the DRE has said that if you are whatever you are using, if you know that it's been compromised, they say we're okay with it, but if it's been compromised and it's been compromised and you continue to use it, that's going to be a violation. So folks, don't be sharing usernames and passwords with people. I don't think you should be sharing it with your TC. I think that file belongs to you. And I had a conversation night before last with an amazingly good broker, and we agreed, you're the captain of the ship, and so I'm going to hold you accountable. And usually in a real estate transaction, somebody will have a transaction coordinator, and I'll always have the conversation with the other agent. I'll say, well, I don't have a problem if I get a written instruction from you to correspond with your TC. I'm okay with that, but I'm always going to have you in the to line. I will put the CC. I will put the TC in the CC. Okay, so the TC goes in the copy line, but I'm never going to only communicate with the TC. It's always going to have you in the to line because you are the agent in the transaction. The TC is not. And I see that violated so many times. And that's why I said earlier, I'm writing a paper for the Department of Real Estate on the activities of transaction coordinators. There's some really good ones out there, folks. And then there's some of them who think they should go to law school, and I recommend they give it a shot, right? right? Okay. So FIRPTA, my Foreign Investment and Real Property Tax Act, a very important form. It can sometimes contain Privacy Act protected information like Social Security numbers and things like that. So your conversation with your agents, your conversations with your TCs, your broker manager, even your broker manager, you should keep copies of all of your correspondence with your broker manager. I have one that they're very clearly going to keep all those documentations because it's going to get rough. Okay, so affiliates, you talk to your title rep. Keep a log of all those things. Okay, write them down. Doesn't have to be word for word, but if something juicy in there, then you absolutely, like for example, your title rep tells you that there's a notice of default filed against the property. I'm writing that down, and then I'm going to get a copy of it too, right? I want a copy of that. So all of your emails, I recommend that you put the address line in your email in all of your emails back and forth. And again, remember that trick I just showed you with the ZipLogix email address. Your conversation log, obviously, your written contemporaneous notes at or about the time of the conversation. I remember I had a conversation. I had somebody call me. I was just leaving was it a Chargers game? I think many years ago at the Coliseum, before they leveled the Coliseum. But I had one of my attorneys sitting in the seat next to me. I'm driving, he's a passenger, and I've got a conversation going on with somebody, on the Bluetooth on the phone, and when I got done with the call, the attorney turns to me and says, "You're going to log that call, right?" I said, "Absolutely, I am," because this was an agent giving me legal advice, and so that's always something that I'm going to get. I'm not going to go to jail with you, as I always say. So definitely. And then the attorney's sitting there going, "I know you will." I go, "Yeah, I will." So written at or about the time the conversation occurred. It's a pretty safe bet, folks. And I said this earlier that you're probably going to be the only one with notes. And all of my successful things, it's always the notes that you took. It's always the confirming email that you sent afterwards saying, "I just got off the phone with you. We talked about this. I want to make it really clear that I'd be doing it this way, and you decided you're going to do it a different way, and that's okay. You hired me to give you advice, not legal advice, but transactional advice, and I expect you to listen to what I have to say." Okay, so text messages, and I have a thing about text messaging. Am I going to cover it here? Yeah, I am. Okay, so do not business text. So I did a panel back in my year as president of the association, San Diego Association in 2019. And it was me, it was Veronica Kilpatrick, who is the district manager for the Department of Real Estate. And listen, I always say I love Veronica. I mean, she's brilliant, right? Well, she is, to me, real estate. She is the commission. She's not a commissioner. She's a district manager, but she knows this stuff inside, outside. When I look at when I review a disciplinary action against a broker, she signs it. I mean, it's like, wow. So here I am sitting next to Veronica Kilpatrick. Clearly, I have a lot of respect for what she has to say. Next to me is Gov Hutchinson, one of the attorneys for CAR, and then Robert Sunderland, who I think is one of the funniest attorneys I've ever known. He's brilliant. And so the four of us are up there, and all four of us agreed, do not text with clients. Now, I know I get pushback from my own people that say you got to get into the 90s. And it's like, listen, when the district manager tells me not to text with clients, I'm not texting with clients. In fact, when somebody tries to if they know what my number is and they try to text me, I'm going to block them. So I tell you, do not text me. So do you have software that will record your text messages? That's usually the key ingredient. I had a lawsuit where the agent, very smug agent, he said, I changed carriers. I don't have any text messages. And so, you know what the attorney did? The attorney subpoenaed his text messages from the previous carrier. And oops, they get all of them, by the way. Nobody's going to go through those. They hire people. The attorney has someone who will go through the text messages. And so, are you sure you want all those text messages out there? So I'm just going to say I don't text with people. In fact, I was deposed in a lawsuit a year ago now, where the attorney said, opposing counsel said to me, "Where are all your text messages?" Kind of like a gotcha. And I said, "I don't have any." And she looks at me and she goes, "What do you mean you don't have any?" And I said, "I don't have any text messages. I don't text with clients." And so she says, "You don't?" So she had her whole morning was blown. She had budgeted 4 hours to grill me over text messages that I didn't have. And so, so So keep the emails going. I would probably not text message. You do whatever you need to do. But we're going to have some specific rules we're going to talk about in text messaging. So if you are business texting, be sure to have backup software that saves your messages. You definitely don't want plaintiff's counsel to subpoena your text records. That's because they get everything, right? Stuff you sent to your husband, your wife, your significant other, whatever. You won't be given an opportunity to redact anything. There may be other items in there you don't want them to see. January 1, 2015. And thank you to BPE Law. I've had them speak actually, and I'm going to probably have them speak again at the Legal Affairs Forum this year. But text messages, instant messages, and tweets are not included in documents that need to be kept unless they are designed to be retained or to create a permanent record. And so if your business practice is to text message, then you need to make sure that you have a backup for that you will be able to produce those so that you can at least produce the ones that are incident to that file. So how does the DRE get your text messages? Because they're not allowed to, we passed a rule that said they can't access text messages. Well, how do they do it? They don't have to do it themselves. What they do is they just subpoena the outcome of your court holding, and then they have all your text messages. And so, so listen, do things the right way the first time, and you probably won't have to worry about any of these things. And I'm preaching to the choir. All of you that are here today, you're here because you don't want to get in trouble versus the other 5,000 people that should be here, right? So confirming letters, we talked about that. SDR has theirs. There's the link to it. I don't think it works anymore, but I showed you the confirming letter. I'll send it to you if you want it, okay? CAR did, and there you go. I was going to take you to it, but I've already done that. Isn't that nice? I'll get you moving a little faster here anyway. How are we doing on time? Oh, we're doing okay. 45 minutes, really? So I have an hour and 15. Okay. All right. So we're never going to make it. So trust records, absolutely. If you have them, if your office requires them, then you must provide them. For most of us, so again, you really, most brokerages have gotten rid of trust accounts because except property management, you have to have a trust account because you're handling the money of others, and it's usually going to sit someplace in a bank so that you can do repairs and do stuff like that. But if you are, so you don't have to have a trust account, but you must have a trust log. And so my advice to you brokers on this call, do what we do. We create a trust log for every agent. You just go to the DRE's website. In fact, let me show you this really quick. You go to the DRE website. There's so much stuff up here. It's just really great. You just got to know how to find it, right? So I go here, and then I go to forms, and then I'm going to go down to where is it? I'm trying to think of which ones. Is it these here? Yes, I got it right. Okay, so these forms are available. So CAR used to publish these forms in the Zip Forms program. They've stopped doing that. So if you're looking for if you're doing property management or whatever, here are the forms. They're all here. You can fill them out. You can PDF print them. You can do all kinds of stuff. But these are the forms. And so my advice would be to use their forms, right? CAR says, we're going to use their forms. So why are we still putting them in our Zip Forms program? So here it is, separate record for each property owned and all that. I should have probably showed that to the people this morning, but whoops, there it goes again. That's a crazy little program. Okay, so good. You don't need to see all that. Do you care? No. Okay, so if your office requires them, then please provide them. All right. Okay. CAR has discontinued those forms and now refers you to the DRE website, as I said, dre.ca.gov. Again, I'll send them to you, or I'll send you the link to them if you want it. Deposit receipts, otherwise known as checks, but our deposit receipts. So our purchase agreement used to be known as the residential purchase contract and receipt for deposit. Well, we don't call it a contract anymore. We call it an agreement. Contract is something we're trying to enforce. An agreement is something that's like nice between the parties and all that. But we used to have and receipt for deposit, which meant we had the check. But we don't take, as a policy, we don't take the check anymore. Again, follow your broker's advice, whatever your broker wants you to do, but you really don't need a receipt unless you actually took the money. Okay, you have the money. All right. So purchase contract. DFTs, I talked about that already. Deal fell through. So make sure that anything signed by a party, whether it closes or not, that you have that on your file. I have behind me, I've been going through files. I literally was throwing files away from 1984. Okay, so before most of you were born. So I was literally throwing away files. I said, it's just, that's enough. That's what is that, 40 years ago? I have files from these things. I had files on the houses. I kept the one that I bought. It was really interesting. I bought a house back in 1984. I'll never forget it. And the file had like 8 pages of paper in it. Today I couldn't, the contract's 16 pages. So cancel checks, why are we keeping it? Well, first of all, for professionalism, our clients need it, and they need our defense a lot of times. The Department of Real Estate requires it. It is within your standard of care. So again, as a standard of care expert, I'm telling you, it is within your standard of care. You have an obligation to keep them. Broker has a legal duty to supervise. And so the DRE requires it. California law requires it. If you're going to be involved in litigation, it's going to be for failure to disclose. It's just the way that it's going to work. So why not export to archive? And I want to show you this. So folks, so a couple of things I'm going to tell you in a minute, but here is the back to the program here. When I go up here to this blue drop down and I click on that, remember this is where I had email to transaction. Well, I also have export to archive. So I click on export to archive and it says you want to send all these things. And the answer is don't uncheck any boxes, because the how many hours have I spent on the phone with Lone Wolf? And again, I'm on the customer advisory board, so so they listen to me when I talk to them. But literally, export it to archive. Why? Because what we're going to do is after 5 years, we're going to shred the program. We're going to shred everything. So when you click on export, it's going to say, hey, it's 6 megabytes. Where do you want to export it to? And you click on export, and then what it does is it sends you an email when it's ready, and then you'll go ahead and you'll save it somewhere on your computer. So it saves it as a ZFX file, so it's a compressed file. But I would be doing this, folks. I mean, if you're doing like with us, we're doing hundreds of transactions every year. Obviously, we have the energy for it, and we're saving all of them. We have everything. I mean, we're not going to rely on this program. We'll have it in here. We're not going to ever delete a program or delete a file, but they will delete. They will shred the file at 5 years. Anything that has a Zip Vaults account in it, a Zip Vault would be anytime you've had something signed by somebody, that will automatically create your Zip Vault account. Okay, signed in the program, and it'll put it over here. It'll give you a folder. Now that's how you create your Zip Vault account. So you don't do it manually. It does it for you. And it will save, the whole thing will save for 5 years. So if you don't touch it for 5 years, we're going to shred it. And by the way, we can't get it back. So that's the same rule. If you delete the file, we can't get it back. So you can't get it back. We can't get it back. And that may have been the one thing that saved you from losing a really bad lawsuit. And so my recommendation is you never delete a file out of here. That is risk management. If your broker has, if you're using the broker version, my advice is to, if you are the broker, my advice is to make sure that you check the box that says that the agent may not delete files. Okay, so anyway, so I showed you how to export it to archive, and then we save it in a backup place just in case, we don't have access to this anymore for some reason. Okay, so good. That's good information to have. So why not export to archive after you close the transaction, right? So, and then I showed you the Zip Forms platform. I get a little ahead of myself here. If you've done all the above, then why not, right? So, so I want to make a note that, so I said that once you've created that zip file, the Zip Vault account, right? You want to export all of this stuff and save it on your hard drive or wherever you're going to save it. But if you don't touch, so like right now, we haven't had anything in this file signed. So this is the first rule is 5 years. With a Zip Vault account, we're going to shred it. If it doesn't have a Zip Vault account, which means you never send anything out for signature, then we're going to shred it at 18 months. So just as a rule of thumb, well, you haven't used it in 18 months, a year and half of the forms have changed. More than half of the forms have changed. So you wouldn't want to use it anyway. So if you haven't had anything done in the file, we're going to shred it for you at 18 months. Okay, everybody good with that? But again, if you have a zip vault account in there, then we will shred it within 5 years. So all you got to do if you're worried about that is go back in, open it up, move it around a little bit, and then close it, and it'll save it for another 5 years if that's important to you. So when DRE requires that you give it all to the broker within 72 hours. So some of this stuff I'll speed up a little bit because there's a little bit of some redundancy here. But because the broker's got 5 days to review or disapprove, that includes your listing agreement, by the way. You get property listed, the broker may decide they don't want the listing. Okay, so 5 days. Again, less time. Where broker shall retain a copy. We'll get into the weeds just a little bit here. Broker shall retain a copy of such documents by causing a paper copy of the document to be made. This is the old rule, or by using electronic image storage media. By the way, I said earlier, the DRE likes the zip forms program. So, but you've got to hope and pray that you have internet access if you get audited, because if you don't have it, you're going to have a problem. We're going to see why. But if you're going to save it on a disk, then electronic image storage pursuant to 2729, and I showed you 2729 a minute ago. Do I need to show it to you again? Let me see here. Where is it? It's over here. And here is 2705, and then obviously I scroll down to 2729. Where is it here? It's away. There's 2724 minimum requirements, right? So I'm not going to waste your time with it, but go to 2729 and you're going to see everything I'm showing you here, right? So write only. So specifically, they don't want you to be able to delete it. Now, again, do you have to do that? Not necessarily. If I save it in the zip forms program, you can't really delete. In the zip forms program, interestingly enough, it retains a history. So I usually, whenever a file's been subpoenaed, I usually want to see a copy of that history. So, but write only. And then we have the UETA, that's the Uniform Electronic Transactions Act. And so the broker may retain copies of such documents at a location other than the broker's place of business. And I get asked this question a lot. I remember back in the day of the rock people, what we did was, we had a whole warehouse full of files, and we had them actually indexed, so that if you took a listing on a property or you were involved in a transaction, we had people that went and looked for that. Did we ever touch that before? And then they're going to pull all the disclosures out of it and make sure that these happen again in the new transaction, right? And we're pretty good sized targets. So yeah, you don't need it in your office, but if it is in your office, and I remember I did an audit prior to the DRE coming in, I did an audit on a broker's file. He has a filing cabinet. It's 2 drawers, so it wasn't doing a lot of transactions, but the key was in the drawer. And I told him, I said, when they come by tomorrow morning, that key needs to be in your pocket, and that needs to be locked, because if they see that key hanging there, then they're going to think that this is not a locked file. Okay, so again, you're responsible for that file. So regulations of the commissioner, I showed you that a second ago. A real estate broker may use electronic image storage media to retain and store copies of all listings, deposit receipts, canceled checks, trust records, and other documents executed by the broker or obtained by the broker in connection with any transaction for which a real estate broker license is required. Folks, that's a big bucket, right? That's a big bucket. That says you're going to hang on to everything, okay? So if you got to call me on the phone and ask me the question, the answer is probably going to be, yeah, hang on to it, okay? So provided the following requirements are satisfied, and again, we're going to go into that non-erasable, write once, read many, so a worm, right? Some of you I know are technically inclined more so than I am, but essentially that means once I write it, I can't take it off of there. And then that does not allow changes to the stored document or record. The stored document or record is made or preserved as part of and in the regular course of business. So if it's the only transaction that you save that way, they're going to be very suspicious. Okay. What they used to do is they used to come into the office and they'd say, show me the trust log. They would go to the trust log and they would reach in, they would grab this one, and then they would go through that. And if they didn't see anything wrong with it, then fine. But if they did, then they would grab the one before it and after it, right? Because they're looking for pattern. And again, as I said to you this morning and in many classes that I've done, have a system for how you handle all this, because if you have a system, they will look at whether the system's got a problem versus the problem itself, right? So sometimes we have systems and they don't catch things. So we want to make sure that we've got a really good system in place, because the system sometimes is easier to defend. So for example, there's a very large broker in town who had his license suspended because his office, his company, big company, did not have a system in place to monitor the expiration dates of agents' licenses. And so there was an agent whose license expired who continued to receive commissions after the expiration, and no real attempt to renew the license. And so the commissioner came down and suspended the agent's license for 2 years, suspended the broker's license for 1 year. Suspension means you can continue. Usually, it means you can continue to do business, but we're watching what you're doing, and of course, if you do something again like that, we're going to revoke. So we don't want that to happen. Okay, so the original record from which the stored document or record was copied was made or prepared by the broker. So did the broker put it together, or the broker's retained staff or employees at or near the time of the act, condition, or event reflected in the record, right? Simple, same thing we're talking about with you. The custodian of the record, whoever that is there, is able to identify the stored document or record, the mode of its preparation, and the mode of storing it on the electronic image storage. End of sentence. Number 5, the electronic image storage system contains a reliable indexing system. This is important, okay, that provides ready access to a desired document or record. So in other words, when they march into your office, usually, actually nowadays they tell you they're coming, but they're not going to sit there and wait for you to fish through your files trying to find it. They're there to do their review really quick and get out. They don't want to spend the day there unless you do something that requires them to spend the day there, and then they may end up launching an investigation. Remember, if the DRE investigates you, they charge you for the cost of the investigation of you, and so it can be a very expensive opportunity. Okay, so provides ready access to a desired document or record, appropriate quality control of the storage process to ensure the quality of image documents or records. And again, I think you really should be thinking about the zip forms program. So, and the date ordered arrangement. They're going to look for your file to see if you can find things fairly readily. Okay, they don't want to wait around for that, right? Okay, to assure a consistent, logical flow of paperwork. All right. And to preclude unnecessary search time, because they don't want to spend time there waiting while you're trying to figure out where everything is, or your internet's not working. You see what I said? It's like, oh God, you don't want that. Okay, records copied and stored under this section shall be retained for how long? 3 years. We've had it drummed into our head since we got our real estate license, and it's pursuant to B&P Code 10148, right? You got to keep it for 3 years, okay? So that's the regulation, the law and the regulation, because it's also the commissioner's regulation that you must keep it for 3 years. Okay, so should you keep it for longer than that? And I'm going to tell you yes. 10 years, I don't know. I would probably keep the disclosures for sure, but again, I did my export to archive. But again, you might end up having to use some of that to defend yourself. But again, if there's going to be a problem, it's going to be in the disclosures. Okay. All right. So all things for 3 years, but specifically the disclosures for beyond 3 years. Okay. So a broker will maintain at the broker's office a means of viewing or copying those documents because the DRE does not bring a copy machine with them. And then I showed you the code a minute ago, and there's my record retention 2729.5. A broker who obtains documents in connection with any transaction for which the license is required when such documents contain an electronic signature. Now we're talking about electronic signatures, right? Pursuant to the UETA, shall retain a copy of that document, including the signatures, again for 3 years, okay, minimum. All right, okay. Broker shall retain a copy of such documents by causing a paper copy. We've talked about this already. 2729 electronic image storage media, and again, you may retain it. And by the way, these are sections, multiple repetitions within the code, within the department's regulations. 2729. So I'm showing it to you again because each one covers a specific area of what they're trying to get at. I would just keep everything for 3 years. Okay. So, a means of viewing them. I think that goes back to the old microfiche days. And after notice, okay, they'll let you know they're coming. Such documents shall be made available for exam, inspection, and copying by the commissioner or their his or her designated representative. Okay, so special investigators is what they call them. So during regular business hours, they're not going to show up on Saturday morning at 8 o'clock. You know, whoo, some of us breathe a sigh of relief. Broker shall retain a copy of those documents by, at the broker's expense, a paper copy if requested. And so if they want paper copies, you're going to have to print them. I remember I helped a broker got audited up in where was it, Oceanside, and on a transaction up in Corona, and the DRE sent a letter, said send us copies of the file, and so paper copies of the file. And so that broker, who had 5 different email addresses, was, you know, frantic. They gave her 2 weeks, so I mean it's like plenty of time, right? But now she says, well, I got 5 email addresses, how am I going to find all those emails? And so literally boxes full of emails to go to the Department of Real Estate, and the shipping alone was expensive. But rather that than actually have to handle an audit. Okay, so you might be required to do a paper copy at some point. I know you don't need a paper copy, you know, throughout time, but I know that at some point, if they ask for it, they may ask for a paper copy. And so then in C, of course, nothing in this section shall be construed to permit a broker to avoid compliance with 10148. So in other words, no matter what we said in here, if it conflicts with 10148, then we don't want that to happen. Okay. All right. So there it is, business president 10148. I showed you that a minute ago. A licensed broker shall retain for 3 years copies of all listings, deposit receipts, cancel checks, trust records, other documents executed by him or her or obtained by him or her in connection with any transactions for which the license is required. So anything you touch is going to be required that you have that. The department may suspend or revoke the license of any broker, salesperson, or corporation licensed as a broker, as a real estate broker, if that person knowingly destroys. Can you imagine? We're coming to your office on Friday morning, and then Thursday night you're in there burning the files. That would probably not be a really bright maneuver, but okay, you know, you'll go for that. That have been sought in connection with an investigation, audit, or examination of a licensee by the commissioner. Remember that the file belongs to your broker, and this is important. Okay, so we're going to shift gears, get out of out of the weeds a little bit here, but remember that the file belongs to the broker. So what we always say is that you don't have a shadow or a ghost file. Remember, that's what people used to call it. They would have their own file. And so, you know, the agent will come into the office and hand me a file, and I go, where's your file? And they go, well, there it is. Now, that's not your file. I know that's not your file. You're giving me the minimum of what you want to give me to get paid. That's all you care about. But I want to see your file. And then, of course, invariably, I get a file that's like 5 times bigger than the file that they handed me. And so if they even had a file, right? So a shadow file or a ghost file meant that the agents were hanging onto their own files, and that's where all the good stuff was, right? Remember, you want the broker to have that, because if there's ever a lawsuit or an audit by the Department of Real Estate, you want the broker to have the file, because the file, that's what the broker defends with. And if you've held things back and stuff like that, the broker's going to say, hey, you held back on me. I didn't know you did that. And so, you know, that broker duty to supervise. Well, if you lied to me or you concealed things from me, well, then I don't have to defend that. I'm just going to say it's on you. And guess what? They're probably going to win that argument. Okay, so your broker's file needs to be bigger than your file. So the file that your company has should be larger than the file that you have. Okay, and yet I always find it's always the other way around. Privacy Act, remember all that. Where? So zip forms. And again, the DRE, as I said a minute ago, zip forms will automatically shred the file when it reaches the 5-year mark. An untouched file with no zip vault account, as I said, will be deleted at the 18-month mark. Again, you didn't do anything with it, so why would you keep it, right? So let the program delete it. It's okay. You've had it all along, as I said earlier, right? So you've had the ability, and I've actually already showed you a lot of this stuff. So any questions so far on what we're talking about? I drink a lot of water. Okay. All right. So that being said, just click your heels together. I put that in there. Just click your heels together 3 times, right? Now you've had it all along. Use your Zip Forms program. It's a great little program. Does all kinds of stuff. And I should probably show you. There's a part of this program. So in here, and of course, it's going to take me to the form again. I'm having trouble with my mouse actually double clicking itself. Um, so a couple of the things that we have notes. So in here I can create a new note. It's going to time and date stamp it, and I can send it to people as I do it. So I want to be sure I'm doing that. In this case, I'm going to delete that one because I don't need it. But I also have my checklist. And I had somebody call me the other day. I'm working on our checklist right now, updating it. But every time the forms update, I need to update the checklist. But notice this is your calendar. So when you write your transaction, it will automatically put in your calendar the times that you have set up in the contract. I mean, it's it's the kind of thing I wouldn't be able to design, but that's my calendar. And then I also have my checklist, right? And so my checklist, I can create a new checklist. And what am I going to call it? We'll call it Bob or something like that. Save, and so now I can start adding tasks to it and doing things like that. I recommend that you use this. It's actually a pretty good part of the program. Now, a lot of us think, well, I'll just hand everything over to the TC and they'll take care of it. But remember what I said earlier, I'm going to hold you responsible for that. Okay, so even if you're handing it over to the TC, so you can give it the task, give it a name. It can have a fixed due date. Is it required? Yes or no. Here's today's date. So obviously, if it's a fixed day, let's say it's due next week, the 7th, I can put that in there. And then I don't have any categories, but who am I going to assign it to? I want the seller to do it. Has it been started? Not started yet. Notify the responsible party when it's due. You have all these available to you. I don't have an email address in there, so it doesn't like that. But I can also share the task via the community file. I can attach documents to it, and I can give it a description. Is everybody good with that? Kind of a neat little part of the program. I wish we used it more, but we just handle so many of them. We have another automated process in which we do that. Okay, so you do have your checklist, you've got your notes, so obviously you clearly have your documents. And then again, as I always say, I've got my history, so I can look to see what was done. I can also go into my e-sign platform, and there won't be any in here, but I have a whole row of all the things that were signed during the course of the transaction. Everybody good there? Okay, so I really like that part of the process. So broker version of Zip Forms, I like the broker version. It has gotten very expensive. I actually was on the phone today with a broker who got that version. I mean, I can do miracles with the broker version, but it's expensive. Not everybody can afford it. And so this person went ahead and got it anyway. But it's good for when you want to create a company-wide template. So what we did when we had it was I created a template that was up at the higher level, obviously, and each of the agents that were within the program, they would go apply buyer offer template, seller listing template, and then they would have all of my templates already done there for them, so they didn't have to really do anything but input the name and the address and the price and all that kind of stuff. So pretty good program. It's really good for broker supervision if you're a broker running a company. But they charge you by the number of seats. So I think the first 10 are a certain price, like $1,200 a year. I let it go at $750 a year because I thought that was getting, and I was teaching it, and I don't get a break, right? So it's like, all right, so anyway, our business model, we do everything for the agent anyway, so they don't really need to have that stuff. So DRE says it's okay as long as your file is not compromised, and I talked about that earlier. As long as you're using a program and using it consistently, that's good. If you know that it's been compromised and you continue to use it, that is not good. So the DRE says if you do continue to use it, they're going to call that a violation. Okay, so don't do that. So in the new RPA, you know that that's in part of your definitions in the new RPA, right? So when I go into here and I go to the RPA form, and it's going to actually say that in the document itself. So I'm going to go down here to the definitions, not wanting to get anybody seasick here, but it's going to be down towards the end. And let's see, here's my electronic. It really cracked me up about the electronic signature. They had never bothered to say in the contract that the electronic signatures would be binding on all parties. And so that actually was a silent revision that they did within the last year. Let me see, delivery, where is it here? Oh, here we go. So under K, under deliver, under K. So it says right here, links could be, for example, to Dropbox or Google Drive or other functionally equivalent program. If the recipient of a link is unable or unwilling to open the link or download the documents or otherwise prefers delivery directly, recipient of a link shall notify the sender in writing within 3 days after delivery of the link. And that's going to be the RFR form. In such case, delivery shall be effective upon delivery of the documents and not the link. So we're going to default to the link, right? But and we do it all the time, and our clients do it all the time. It works out really well for us. And by the way, when they use that, you send that email address to the client. I always tell the ZipLogix address. I always tell everybody reply to all, so that also goes into the file. And then you also have the ability to the client now has the ability also to email documents into the transaction for you. So one of the things that I do a lot of that I really like is the share feature in the program. So in this case, I have parties in there. So who's here? I'm a party. I can click share up here, and it's going to say, what do you want to do? And I'm going to say, click to start sharing. And then I'm going to share it with, where am I? I'm right here. I'm going to share it with myself. And then it's going to say, give me permissions to do. I can, obviously, if I'm sharing it with the agent, the other side's agent, then I won't let them edit forms. I will let them upload documents, right? But I'm going to give them limited ability to do things. And then it has a stop sharing date. I click on next, and then it says, share these documents. So maybe I'm sharing the disclosures. Maybe I'm sharing all the signed disclosures signed by the seller with them, right? And so I'm going to go back here, but this is a really great little feature. I've had a couple people that are like freaking out when I sent them. I had one TC said, I don't want access to your file. I was like, you're not getting access to my file. You're getting access to what I'm going to give you in my file, right? So they had a real hard time with that. But then I hit save and send, and then it comes back and it says, send a nice little letter and whatever that little letter is going to look like. And then I just click on send. Okay, so it just sent me that, by the way, on my email. So hit my back button, I'm back in here. That is a really cool feature. And I think, again, if you do it this way, it's saving it in the program for you. When I click on history, look at that. It just says I sent an invitation to collaborate, and what was included. There wasn't anything included in it, but this is what it looked like. There's the message. So I'd have a record of everything that I've done. Everybody okay with that? Kind of a neat little feature. I like it. I use it extensively. Sometimes I get pushback from agents who don't understand the concept, but again, get into the 90s, right? So all right, so where are we? We're Google Drive, etc. Locked in the filing cabinet in the broker's office. So I put that in caps, or rather in big bold font, because if you have it in a filing cabinet in paper form, it must be locked. Okay, and so so we went to, in some of the companies where I was management, we went to great extremes to not only lock it in a filing cabinet, but then also lock the room. So when the broker left the room, they would lock the room behind them, and that was for DRE compliance, right? So locked in the filing cabinet. So how long? Okay, so again, just quickly, DRE requires, and it looks like we are going to get out of here early, but DRE does require 3 years from close of escrow. If close of escrow, that's transfer of title from seller to buyer. Some states where I teach, they call it settlement, things like that. Or the documents themselves, if the transaction never closed. So if you wrote an offer and it did, and the transaction never closed, you still must retain that signed document, right? It's material to the transaction, even though the transaction really never moved forward. So you would still have that document. Again, the DFT is an example, and the broker that said, no, we throw them away. It's like, well, you just broken the requirement by the Department of Real Estate that you save anything material to the transaction. Closing a screen over there. Okay. Records copied, excuse me, and stored under this section shall be retained according to 10148. For how long? And again, the statute of limitations to file a suit is generally roughly 3 to 4 years, depending. Some things are 2 years. So, for example, a defective TDS, the buyer has 2 years to sue on a defective TDS. The attorneys are probably going to go for more than that, but if they get the lawsuit started in time, 2 years. But 3 to 4 years generally, depending on things, unless, of course, and again, I always say depending on the circumstances. For the statute of limitations for fraud now, there is 3 years from the date of discovery. So the buyer discovers 5 years. I had a lawsuit not that long ago where the buyer discovered, it was funny, I had sold the buyer the property, and then 7 years later, they decided to sell it themselves, and they found a buyer who bought it from them. I had nothing to do with that second transaction, but they called me and asked me, would you please come in and testify on our behalf that the property, the way we sold it was the way that we bought it, that kind of thing. So I wasn't a party to it, but again, why were they getting sued 7 years later? They were getting sued 7 years later because their buyer didn't discover the fraud supposedly until year number 4, and so they had 3 years to file the suit. So essentially, there's really no statute of limitations. I think the court's going to argue probably otherwise, but again, it's 3 years from the date of discovery. So 3 years from the date when they found they've been defrauded. Right now, remember, fraud is the most difficult to prove, but it also has the greatest return on the investment. So people will allege fraud just to get in front of a judge, and I've had that before. I had a suit where I was there, and the judge turned to opposing counsel and he says, I'm looking at your complaint, and I don't see, you're alleging fraud, but I don't see the fraud in the complaint. There's no facts supporting fraud. And the attorney's comment was, well, I figured you wouldn't hear my case unless I alleged fraud. I thought the guy was going to get disbarred. I mean, that was just a stupid thing to say, but all right, I'm not in charge of that department. So anyway, the case was over at that point. I got to go home, and I got a lunch out of it and everything. It was pretty cool. So except when required to file it, again, that was what I said a minute ago. So probably best to save, again, export to archive, all of your disclosures, folks, all of your disclosures, save all of those, because those are going to be what you're going to need later on. You're almost always getting, your defense is almost always going to be based on a disclosure. I remember I took a listing on a property in Lake Forest, and slightly outside of San Diego County. I sat with the seller for 3.5 hours and went over all the disclosures. If you want to bet, I had probably the most ironclad listing file of anybody. I had everything. I had the NHD ordered. They went over that. They had bought the property. They had a death on the property within 3 years. They bought it from mom. Mom had increasing dementia. And ultimately, mom passed in the property. So they made the disclosure of the death on the property. That's Civil Code, California Civil Code 1710. Death on the property within 3 years, manner of death, natural causes, and there were unpermitted additions in the property. They disclosed everything. Okay, so I'm sitting there going, all right, we got a whole and again, remember, no right to rescind the contract if they give the statutory disclosures before the contract was created. The buyer's offer we sent over the counter with all the disclosures, and the buyer's comment was, well, what do we need 30 days for? We can close it in 13, and they did. They closed it within less than 2 weeks. So, but we still have that file. That buyer, by the way, went in, remodeled the property, and then resold it. But so I'm always worried about that chain of events, right? So now there's a new buyer in the property. Does that buyer litigate against the seller in the transaction we didn't have anything to do with? And then they try to bring us into it later. I'm going to have all that stuff. So all those disclosures and all those things signed by the buyer are going to be part of my file. Okay. All right. Forever, I think. Again, you can always, if you don't trust the Zip Forms program to hang on to it, you can always export it to archive and save it. We save them in our Google Drive account. That's where they all go. They're compressed files. They don't take up a lot of room. Okay. All right. So best practices. Let's take a look at an example. zip form is probably your best bet. It is the standard of practice in San Diego. Question. Hi, Adriana. Do you get an email confirmation when you share your disclosures through zip forms, or do you still have to send an email to get that receipt record? I'm not sure if I understand. Do you send your disclosures out from within zip forms? And the answer is you will, if you're sending the disclosures, what we normally do is we send them to the seller for signature, and then once the seller signs them, they bounce to the other agent, if that's what you're referring to. And we have a record of that, so we'll see that and we use DocuSign for that purpose. So we'll have a record in DocuSign. We'll also have a record in zip forms, and then again, same thing as I said earlier, I'm also going to have a record here and under history. So here's my history, right? So all the things that I've done in the program. So hopefully I'm answering your question. So I don't necessarily need now your question is actually an excellent question. On a higher level, if you are communicating with people in the manner in which you've been communicating that was successful, and you continue to communicate in that manner, then it's going to be really hard for them to say that they didn't get it, because that's how you've been communicating with them. Sometimes people will, like we've got a broker in our office who sends those read receipts and stuff like that. I never respond to the read receipt. I mean, I'm always going to, X out of it, because, but listen, if you've been communicating with me in a certain way and you continue to communicate with me in that way, then I think it's a pretty safe bet. What I like to do in my emails is I usually like to put in things like, please confirm receipt, or again, if you have trouble with any of this stuff, let me know. I want something back from them. I don't need the read receipt. I want something back from them that says that they got it and that they're going through with it. Obviously, if they send me the completed document, then they did get it. Okay. Adriana, am I hitting your question okay? I may be overkilling it here. Good. Okay. All right. But good question, because, normally we send everything out of this program. Everything goes out of here. I don't have to worry about retaining records and bringing it back into here, because it came out of here. So that's why we send everything from out of this program. If I'm going to send disclosures to the other agent, then I'm going to go, let's go down. Here's my disclosures to send file, right? So I'm going to send them the agents, well, that would be one. Mold advisory, let's just use that as an example. I'm going to click the drop down here, and I'm going to click on send, and I'm going to send it through email, and then here it is. So it's going to give me all this, and where am I going to send it? I'm going to send it to me, and so I hit done, and then I put in here the subject matter, final verification of condition, perhaps, and then, by the way, and again, thanks for asking the question, because in here, your signature line, the DRE says you must have a DRE compliant signature line, because they think they believe that zip forms as well as your MLS are first contact. So make sure that you have a completed signature line in here. And so you see mine, it's got my name as it appears on my license. It's got my DRE number on there. It's even got our corporate DRE number on there. It's got my affiliation with the company on there, and all the rest of that stuff. So make sure you're doing that. All right. So great question. Yeah, thank you. Excellent. Yeah, I know. I like everything going in and out of here. Okay. And then that way I don't have to worry about retaining it later and doing other stuff with it. Okay. So thank you, Adriana. That's a great question. All right. So where am I? It is the standard of practice in California to use the zip forms product. I know there's Glide out there. I think that's the only other product that we license to have access to the CAR forms. I know some people use SkySlope. That's kind of a more circuitous route, but make sure you're using the current forms. Okay. So anyway, so we said that already. Zip forms automatically shreds everything that hasn't been touched within 5 years. So if you have a file that you were working on, and again, as I said earlier, if you want to retain the file for longer than 5 years, just open it up, do something in it, and then close it again. It'll save it for another 5 years, and it'll show you in the one line column. So it'll show you when you get back to this. Let me scroll back here for you. I get back to my list. It'll show you, call these the one-liners. It'll show over here the retention date. So those are the dates that I'm usually looking at when I'm looking at a file. Okay. All right. Good. Whoops. Where'd my thing go? I got it up there at the top now. Okay. Let's see, transactions with no completion date, so nothing in there, no zip vault account, deleted after 18 months. I said that already. Wayne Bell. Now I really like Wayne Bell. I mean, he's an attorney. He was the commissioner before Macaulay was commissioner. I thought I saw a note today or yesterday that there's a new commissioner, but I don't know. But anyway, Wayne was a great writer. He was prolific. He headed up the enforcement division at the DRE for 20 years, and kind of for a period of time a pen pal with me. My signature line on my email, because I was emailing with him at one point, and he said to me, he said, I've got that on my wall in the back of my office. I have a quote in there by John Ruskin, and so essentially, there's other people that always do things for cheaper and charge less for it, and those are the public's lawful prey. So Wayne had a comment. Again, my conclusion, and this is in one of his bulletins, and I can send you the bulletin, but I wasn't able to edit it. It was a protected document, but it says, my conclusion is that professionalism in performing real estate license services, requires licensees to have the knowledge, skills, and abilities gained through education and or practice and experience, and thoroughness and preparation, including organization and diligence, to well and ethically represent their clients. And so, so this statement of his is multifaceted. It's really, for me, it's a fascinating statement. It says, we are going to hold you to a standard that you would have as a licensee. And that's from that education required to get your license. So, interestingly enough, I had a lawsuit where the buyer, of course, is the plaintiff, and the buyer is with their agent. It was a harborfront property. It had a boat slip, place where you dock the boat. And the buyer and the buyer's agent are standing on the dock, down towards the water, and it's low tide. And the buyer says to their agent, says, how does the stem wall look to you? Now, I teach the classes to get your license. I teach the classes to get your broker's license, to upgrade to broker, right? And nowhere in any of those classes in the decades that I've been teaching this stuff is there anything about a stem wall. I didn't know what a stem wall was until I got called in for the defense, because the buyer sued because the agent's comment while they were standing on that little boat slip thing. I don't even know what the part's called. And he said he looked down at the thing that was what he could see above water, and he said the stem wall looks fine to me. And that started this lawsuit. There were millions of dollars in legal fees. I got paid a fortune for coming in, and I'm always the closer. I'm always the relief pitcher, right? So, but I'm going to tell you something. Be careful about what you say. Clearly careful about what you write. Okay, but there's nowhere in his licensing he didn't want to say, I don't know what the stem wall was, because he has sold a lot of harborfront properties, and I guess he kind of figured, the agent kind of figured, that he should know what a stem wall was. I don't know. You tie a boat to it? No, the stem wall was actually below the water line. So, I learned all kinds of things about eels and stuff, the eels that eat the concrete underwater. Remember, it's sitting underwater soaking, even though it's in concrete. I had to watch videos of divers down there, with suits on and going around and investigating this thing. I mean, there was a lot of money spent on this lawsuit, and obviously we won the lawsuit. I say we, but the attorney for the defendant, for the brokerage firm, just one of the most brilliant attorneys I've ever worked with, just fascinatingly bright. And he was skilled at what he did. When I look at this document right here from Wayne Bell, and it tells me, why did you say stem wall when you don't have anything in your education that requires you to know what a stem wall is? Okay. And so, folks, I'm going to tell you, if I tell you nothing else, I want you to remember what I'm going to say here. And that is, that's a really good question. You always want to compliment the question. Let me find out. You don't have to say, I don't know. Let me find out, and I'll get back to you. Okay. And that's the secret for protecting yourself. Okay, you don't want to say, I don't know. All right. That's okay. I get it. Your ego won't let you do that. That's a great question. Let me find out, and I'll get back to you, and then get back to them. Okay. So, but don't get back to them with the answer. Get back with them with where to find the answer. So I had this comment on a podcast I did yesterday with Mike Litton. And I said, be the source of the source, not the source. And so I'll almost invariably always say, it's 755-9313. And people say, what's that? I say, well, that's the telephone number to the City of Del Mar Planning and Zoning Department, right? And so you need to give them a call. You know, I probably have already called them. I won't tell them that, right? But they'll ask me questions like, you know, mold. Well, I have a graduate certificate in hazardous materials management. I got a pretty good idea what mold looks like, but when somebody says to me, is that mold? I say, you know, well, I really don't know. I mean, you need to have a sample, right? We did an inspection on a property. I had the inspector, God rest his soul, has passed away, John Hasty with Countywide Property Inspections, one of the best inspectors I've ever had. And we're in a house built in 1948, and he opens up the door to the furnace, and there's the heater to the house wrapped in, I know what it is. He knew what it was. Neither one of us wanted to say the word. So he looks at me, I'm looking at him. And so his report said to the buyer, you should be checking the property out for the potential presence of asbestos. And sure enough, the buyer had it tested. It was clearly asbestos up into the ceiling. And strangely enough, it only insulated the heater for 22 feet. I'll never forget this. This was 20 years ago. And so, you know, I'm not going to use, you know, I'm not going to use the word asbestos. I don't know what mold is. I always ask people, you know, the difference between mold and mildew. There's nothing in any of these classes that you took to get your real estate license that explain the difference between mold and mildew. So the answer is, that's a really good question. Let me find out and I'll get back to you. And then you need to have it sampled. All the houses I bought, I've always had one exception. I had one house that I bought that I did not have a physical inspection in my career, 44 years of doing this. I did not have an inspection. And when I went in to close the transaction, we had black mold throughout the inside of the property. It had been vacant for weeks. It was summer. You know, it was a very valuable and a very expensive lesson for me. I ended up having to sue the homeowners association because it was their water pipe that caused the mold and all that kind of stuff. And I had stachybotrys, which is toxic mold. And so, you know, originally it was about an $18,000 fix. It was an $88,000 judgment for me, only because they delayed in getting the fix. Okay. And so I didn't make money on it. The attorneys obviously made money, but at least I was made whole. They covered the cost of the work. So be aware, when I walked in there, all I saw was black stain on ceiling, or well, hell, it was all across the walls, ceiling. They tore the ceiling out. It was up there, you know, it was everywhere. But I don't know, it's just a fuzzy, you know, thing. So be careful that you don't know too much. You know, I want your license to be good for you for a long period of time. And so, you know, you know, as Wayne said this at one point, stay in your lane, you know, don't go outside of your lane. That's important. Okay. So, I hope this helps. Potentially difficult situation with a fairly easy solution. Document everything, write everything down, keep all of your notes. I would keep them up in the Zip Forms platform. It's going to save it there for your requirement is to keep it for 3 years. They're not going to shred it for 5 years. So it's going to, you know, I remember when they changed that to 5, and I think they might have changed it again now up to 7. But be aware that program, you have essentially no storage limit. You know, you got plenty of room. So that's what I would do. The DRE has said, Veronica Kilpatrick has said, keep it all in one place. So my example of the broker that had 5 different email addresses, she's fishing everywhere trying to find, you know, these emails relevant to the transaction. The seller sues her. It turns out the seller had a revoked real estate license, and so essentially she was able to turn the tables on him. But you know, that's the kind of stress you don't need to go through. So fairly easy solution. Keep notes of everything. When we consistently maintain our professional standard, you know, you're going to save the day every single time. So I want to thank you for joining us today. I am going to get you out of here a little bit early. A couple things I want to show you, you know, and reducing risk, obviously. So we have the YouTube website. I had been told that all of my videos were being loaded up onto YouTube, and it turns out they hadn't been loaded for 2 years. So I'm loading all my videos up there. And so I want you to have access to that. Thank you, Mary. And Mary, you've seen the rest of this, so you know. But anyway, your QR code. So if you have a QR code reader on your phone or whatever, I'm finding that people love these little QR code things. And so I learned how to create QR codes. So necessity is the mother of invention. I learned how to do it because I found that that these things weren't being loaded, but I want you to have access to it. This stuff is free at this point in time. I'm going to be on over behind me here. I'm going to be working on a podcast after this where I'm going to be talking about the new forms. We're going to publish those, but they're going to be behind a firewall. So the stuff I do for the San Diego Association of Realtors is free to you. But then I have also got subscribers that want to have access to more stuff than that. And so, and again, I want you to be made whole, but obviously I have to, this microphone, this is a very expensive microphone, by the way. I want to thank Donald Sinke, one of our agents who gifted it to me, super young man. He's going to just kill it out there. He's really, really good. In fact, I know I wrote an offer for him right before this class. So anyway, there's a QR code. You could also type into your browser at Burke Real Estate Consultants Inc. Again, I'm not trying to sell you anything. I don't care. I've done well. I want you to look good. Remember what I always say, if you look good, you make me look good. I want you to look good. And then the bit.ly link. Now, the Department of Real Estate's required me, they want me to post a page where I have what's called the general information page on the DRE classes that I've had approved that I'm teaching. So that's why I'm doing all of this and leading it to all of that. You can also, if you go to the YouTube website, and I didn't know this, I didn't know a lot. I didn't know how to do YouTube until, probably 6 months ago, probably not quite even that long. But I learned that like makes me feel good, but subscribe is more important. If you subscribe, then every time I load a video, you will be notified of that when you log into YouTube. So when I'm done with this one, I'm going to load this morning's video, which was, what was this morning? Property management at the beginning. And then I'll load this one right after that. And so you'll have access to it if you want to watch it again, you want to save it, download it, give it to somebody, let the dog eat it, whatever. You can do a lot of things with that. So I want you to have access to that. And then the podcast portion of things, which we haven't put anything up there yet. I don't know what we're going to, probably $5 a month or something, just, because, essentially when I put this stuff up here, I know that the DRE is looking at it, and I love the DRE. I want them to look at it. I have a tremendous amount of respect for what they do. But so does plaintiff's counsel. The attorneys look at these things and see if they can try to slip me up, which isn't going to be possible. But I remember I had a deposition where I answered the question by the attorney, and then we're into court. It went to court. And so I'm in court and the attorney asks me a question and I gave him the answer. And he says, that's not what you said in deposition. And I said, well, counselor, that's not what you asked me in deposition. And of course, I got the jury panel sitting there and I said, that's not what you asked me. And he says, yes, it is. And I said, I'm sorry, counsel. No, it isn't. I've got a pretty good memory for stuff. And so anyway, he goes fishing through his notes and he goes, oh, nuts, you're right. The case was over at that point, right? Because he just admitted to the jury that, he was wrong and that I was right. And so he just completely lost faith. And needless to say, our client was successful in the trial. But that just comes from that. So I want this to help you. I'm not looking to make money on it. So if you have classes or things, we go to brokerage firms. I go to brokerages. I do a lot of this on webinar. So if your broker wants us to come in and talk about something, send an email to education@sdar.com. You can copy me if you want. You can send it to me. You can copy them. I mean, whatever you want to do. I mean, SDAR is committed to helping you increase your professionalism in the business. And so, as am I. And so, independent of SDAR, by the way, so I'm not employed by SDAR. I have other things that I do, obviously, that keep me busy. So we'll see what next year looks like. But that being said, email updates, I send these out once they go out only Friday nights. So tomorrow night at Friday, I'm going to send out my newsletter. It'll have direct links to the webinars I'm doing next week. And then the following week, it's over for the year, right? Because our last webinar will be on the 14th, which is a Thursday. On the 16th, which is a Saturday, we do the forms release. I'm going to be hot all over the internet talking about the new forms. I'm so excited about it. And I sit right there and watch for them to change them. So watch for that. You you won't know unless you've got the newsletter. The newsletter will tell you how to get there, but or YouTube, it'll probably be on YouTube. So, but anyway, the new forms, interestingly enough, with the Burnett decision, the Sitzer Burnett decision that came down a couple of weeks ago now in the Midwest there, we have a buyer representation agreement, right? You all know that, right? California is not so worried about that decision because we're very clear with sellers how much we're paying the buyer's agent, right? It says it right in paragraph 3D of the listing agreement. So, but it's still those kinds of holdings are harmful to us, and so excuse me, just generally speaking. The appeal was filed right away. People ask me about this case all the time. You're not going to know what really is going to happen for years. The appeal's already been filed. All the copycat lawsuits have been filed. All these things that are happening. So folks, keep taking good care of people, okay? Use your buyer representation agreement. Make sure you're thorough in completing the forms. Fill them all out. Don't leave any blank spaces, stuff like that. Just a general rule. But anyway, thank you for listening to me. So if anybody have any questions, anything else that I haven't covered or anything else that you want me to cover, Adriana, QR code scanned, good for you. Check out the video. You don't have to look at all of them, but you'll see there's a lot of them. I just made a whole bunch of them private because they were, I've been posting these now for months. So the ones that are public are the ones that are the newest versions of those things. So thank you so much, Adriana. It's always good to hypothetically see you, even though I really can't see you, but thank you again for being here. And thank you, Mary. You're wonderful. You're so good to me. And I thank you. And Linda, thank you, Linda. Thank you all for your time. Thank you for everybody that's here today. So again, if there aren't any other questions, I want to wish you a very good weekend. And as we say from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Take care for now. Bye-bye.